Hello, everyone, and welcome to a new session with Rights and Responsibilities Awareness Initiative. Today, we are lucky to have John Paul Rodrigues, criminal lawyer and professor. I personally learned a lot from his experience. So thank you, John Paul, for being here with us today.
Thank you for having me. And yes, just to expand a little on that. So my name is JP Rodrigues. I'm a criminal defense lawyer. These days, the only criminal defense work I'm doing is as telephone duty counsel, which is when people are arrested and they get a call to speak to a lawyer and they don't have a lawyer or their lawyer is not available. They're given the option if they wish to speak to duty counsel at that time. And over the years, I've probably spoken to tens of thousands of different people, facing a variety of different criminal charges. Sometimes immigration-related issues as well, or provincial offenses, all the way up to murder charges, from some minor assaults, things like that as well. So I've had plenty of years of experience doing that, and I thought it would be a perfect sort of short topic here to talk about, because not necessarily everyone, based on that experience, knows what their rights are and what's happening during a police investigation. I certainly also spend a lot of time, most of my time, teaching paralegal students at Centennial College and Seneca College. In addition, my main role these days, as I've come to know you as well, sir, is through being the paralegal program coordinator at Trials College, where, again, a lot of paralegal students or anyone interested in learning more about the law can come and study, and by the end of the program, be in a position to complete it, get licensed, and be a licensed paralegal, hopefully one day afterwards. So Hidama, I'm not sure if there's anything, I guess, that you wanted to know specifically there from your group. But...
Yes, sir. First, I would like just to told our audience that please feel free, if you are watching us through any of our social media platforms, if you got any question, please just feel free to type it into comments, and your questions will be answered accordingly. And also, please, this is kindly note that this is a public legal education. This is not intended to be legal advice. If you have any specific legal issue, you are strongly encouraged to contact your legal practitioner. So, yeah, in general, John Paul, if we may started this. As you know, interacting with police could be, for some cultures, intimidating. It could be people will try to avoid any direct contact with the authority. Unfortunately, there's a lot of jurisdictions and countries where you try as much as you can to stay away. And within this scope, how is the situation here? What kind of, what is the scope, the main platform that govern your relationship as a citizen with the Canadian police?
Right, it's certainly important there, and I think you brought it up there that some people, I think probably even most people, if not everybody, when you're encountering the legal system, whether it's in court or contact with the police, there may be that feeling of anxiety, nervousness. And I think that's only natural, right? That you don't necessarily know if you've done anything wrong, and you might be nervous, you might be sweating, worried, and I think that's something that human nature, right? Is even if you've done nothing at all wrong, you just feel this pressure, right? Because these are police officers, or these are judges, or crown attorneys, or lawyers, or paralegals, or whoever you encounter in the justice system. That kind of puts you a little apprehensive and a little worried about what's happening, right? So I think the first and most important thing, if you only take one thing away for anyone listening, is you have the right to remain silent. And I think, as you mentioned, people from other jurisdictions, or even people here from, who've grown up, spent a lot of years in Canada, they don't necessarily think that's something they should be doing, right? So if they are encountering the police and the police stop them and are asking them questions, they think, well, I should be nice, right? I should be answering these questions. I should be helpful, because if I don't answer these questions, then they're going to suspect, something's wrong, and then I might get into more trouble, right? So again, if the police don't stop you for questioning, if they suspect you've committed a crime or they've seen you commit a crime, right? Again, in those kinds of situations, first of all, you should ask, am I being detained here, or am I free to leave, right? Because if you're free to leave, then you may just, again, and most important thing I would say is, of course, be polite, right? Even if you have a right to remain silent, it doesn't mean to be unnecessarily rude to the police officer to, escalate the kind of situation you're in, right? So first find out if, you are allowed to go. And then if you're allowed to go, then leave quietly, right? And walk away. And if you are being detained, there's two things, right? Is again, exercising that right to remain silent, politely say, look, I'm one of the things that we tell people when we speak to them as telephone duty counsel, this nice, easy way to remember it is, lawyer told me not to talk to you, right? And essentially, you're shifting kind of the responsibility to, a lawyer like myself that's told you to remain silent. So, I don't know the law, but this lawyer I spoke to told me not to talk to you, right? So again, easy enough to hopefully remember, lawyer told me not to talk to you, or I have the right to remain silent, or I'm exercising my right to remain silent, and then not answer any further questions. Now, at that point, depending on what's going on, you may be being charged, you may be being arrested and brought to the police station. And you should also exercise your right to retain counsel, which is to speak to a lawyer who can properly advise you in that situation. So even if you forget things like this, knowing that you want to talk to a lawyer, you may have a lawyer you know of, even if you don't necessarily remember their phone number. If you can provide the police officer with their name, they can then make attempts to contact them. And if you don't have anyone, right, and this is what I was saying at the outset, I work as telephone duty counsel, so me and a number of my colleagues are available 24/7, right, for people in that situation. I've taken calls at 4:30 in the morning. I've taken calls at 4:30 in the afternoon when I'm scheduled to work. And again, it's to provide this kind of advice to people who are in those situations, and they may not know their rights, or they've forgotten about their rights. And again, it's very important, like I said, to know your right to remain silent, because of many different reasons, right? If you, for example, answer a question and let's say it goes to trial a year later and you don't remember, right? Naturally, a year and a half when it gets to trial, you may have forgotten exactly what you said. And then on the other side, the Crown attorney might say, well, when you talked to the police, you didn't exactly say that. And now it looks like, there's something wrong with your response because it's inconsistent with what you had said, an hour after being brought into police custody.
Thank you, John Paul, for this. But you've mentioned to contact a lawyer. And as you know, sometimes the legal fees could be something beyond the financial capabilities for so many people. So are those people are denied from getting same treatment because of their financial hardships? Or do they have any other options they might consider?
Right. So again, I would reiterate, at this stage, right? If, for example, you don't have a lawyer, you don't know of a lawyer, and you find yourself in a situation where you are being arrested, or you're being detained, or the police are investigating into something, and you're not sure what to do, right? If you don't know of a lawyer, you could ask, can I speak to duty counsel? Can you contact the free lawyers available through Legal Aid Ontario? And again, regardless of that situation you're in, it's free legal advice that again, as soon as possible in the given circumstances. There's all sorts of scenarios where it may not be instantaneous, like for example, If you're pulled over by the police while driving, they suspect you've been drinking and driving, and you want to talk to a lawyer. It won't necessarily happen right there at the roadside. It may happen when you're brought back to the police station. But the sooner you assert that right and let them know you'd like to speak to a lawyer, and if you don't have one in particular that you know of, then you could say, I'd like to speak to duty counsel, and the police would also mention that to you. You have that right as well. And again, even if it's someone usually in that circumstance, again, I can't speak to for all criminal defense lawyers, but if someone calls them, calls me, let's say, and they say so and so is asked to speak to you, I mean, that phone call, whether it's 5, 10, 20, 30 minutes, usually, I mean, I think you should hope that it'll be done free of charge. So even if it's you can't, you don't want to talk to duty counsel, and you have that special connection, maybe it's someone you've met or heard, and from other experiences. Again, in those situations, I would imagine that they'd be able to take that call, depending on the time, of course, but usually free of charge. So hopefully that puts you on like the same playing field as someone who may have deeper pockets, as you said, who would have access to lawyers.
Thank you, John Paul. So could you please elaborate more on the duty counsel position, and when this assistant is available, and what is the limitation for such help, please?
Yeah, so there's no, I mean, in terms of, let's say, being arrested or being detained, again, if you find yourself in that position 24 hours a day, 7 days a week, holidays, the duty counsel hotline there is available. That's again run by a third party on behalf of Legal Aid Ontario. So police officers know, and security guards as well, if that's been requested, right, they'll call a 1-800 number, and then they'll leave a voicemail basically explaining, they've arrested or they've detained so and so. These are the charges, and they'd like to speak to you, and then the telephone duty counsel lawyers will call back, in a reasonable time frame after that message, depending again on how busy things are. And at that point, the officer will facilitate that phone call. So the person, sometimes again, I've spoken to people in that role. They're at their house, and there's a search being executed, and the police call. Right, sometimes it's at the scene. Something may have, they've been charged with theft, right? And then they're at the security office at Walmart, for example, and, they want to know their rights in that situation. Or other times, and most commonly, they're at the police station, and they're in the custody there, and we have that phone call. So again, there's no limitation, right? If you find yourself in that situation and either you don't know of a lawyer, or the lawyer that you do know, the police have tried to reach, and either they're asleep or otherwise unable to pick up, and they give you that option then to contact telephone duty counsel, who can then, like I said, go over the situation and provide you with some advice as to, essentially, like I said, making sure you know to remain silent, making sure some of the other provisions as they apply, and what the next steps are depending on what's going to happen.
Thank you very much. So what are the circumstances that would, for example, I'm not going to say force the police or make the police most likely arrested the person? What are those circumstances that could get the officer at the point where there's no choice but to arrest that person?
Right, so it depends obviously on the the type of offense, right? The more serious, if it's like an indictable offense, then you're going to see that more likely that there's going to be an arrest made. Usually, there's what they call the rice factors, which stands for if they can't identify the person, right? Maybe they don't have a driver's license or something on them, or if they don't want the offense to could be continued or repeated. If they let them go, they're going to go back and let's say they're damaging property, so it would continue if they weren't arrested and brought to the police station. Again, if it's something in terms of preserving the evidence there, right? I mean, so a number of factors as well. I mean, the other thing that they may be looking at is again, if if they are thinking about maybe holding them for a bail hearing, right? If they believe they have grounds in a situation that they're going to keep them in custody and then bring them to court the next day, because again, either this has been a situation where they're not sure again if this is going to continue if they don't bring them into custody, and no, again, they would look at in that light, is it better for us to bring them in, or is it, can we be satisfied if we release this person here at the scene, we give them an appearance notice to appear in court on a certain date and certain time, that they will do that, and it's not going to be an issue otherwise.
So thank you very much. So in the case of arresting, do the police have the right to search the suspected, the accused? Can they search his wallet, his phone? Can they access his private photos, messages, even if they are not related to the incident that he's pulled over or stopped for?
Right. So, I mean, again, one of the common answers you'll get when you're speaking to a practitioner is it depends, in the context of a situation, what's reasonable grounds there to look at. But I mean, generally, if you're being arrested, the police there have to make sure, if you're being brought into custody, you don't have any weapons on you, because it could be dangerous, unsafe for them or anyone in custody. They can search sort of the immediate vicinity around you there, or when you get to the station, they may do an inventory search to see what you have on you, so that when you are released later on, if you're released, then they can return any belongings you have. So in that capacity, right, then they certainly can search you if you're being arrested, and for those reasons. But again, if it's something absolutely unrelated, and it's not in the immediate, they can't just, okay, we have you in custody, we're gonna go and search your house, or we're going to go and search your car now, right? I mean, they have to have a warrant, right, in those situations. And then whatever is on the warrant there, right? So if they get a search warrant to search your house, then they can search your house under the terms of that warrant, right? If the warrant says search the house, it doesn't mean you can go and search the car or another property, right? So it's specific to that. Again, in some situations, right, if there's a crime in progress, right, that they don't need to go with, like, again, it doesn't make sense to then go and get a warrant. Like if they see that you have, for example, a gun on the passenger seat, it's in plain view. Again, they don't need to go and get a warrant to then search and seize that gun. They can do that because, again, it's in plain view of what's happening.
Yeah, that makes sense. So one of the main concerns, or let's say the main debatable points, that when police have to use, when they forced to use the force in order to arrest someone. We all remember George Floyd, for example, in United States, when that American police just used that excessive violence during the arresting, and that lead to strong demonstrations in most of the United States cities. So my question to you is there any level tests, training, policy regulating when or how the police should use their power and their force in order to implement the arresting process?
Yeah. I mean, I think, again, the word reasonable, earlier I was saying, it depends. That people will say that. The other is reasonable. What's reasonable in a circumstance may not be, across the board, right? It's not going to be like, this is exactly to the T what has to be done every single time, because, again, if someone is resisting arrest, right, if there's like a little back and forth, right, they may need to be, a little bit more, let's say, assertive in diffusing that situation, right? So obviously, if someone is there, the police place the handcuffs. There's no reason why you need to use excessive force, if there is no need for it, right? I mean, there's no need for excessive force, period, right? So I'm just saying that where they may use some kind of force, it has to be reasonable in the circumstances, right? If someone's trying to flee or someone's fighting back, right, that they need to sort of diffuse that situation without it, putting the threat to others, people in danger, right? So again, that doesn't mean that they can do whatever, right? If somebody is trying to get away or whatever, it doesn't mean that they can start shooting at people or tasering people. But again, what's reasonable in the circumstances, and you have to also appreciate, these are like split-second decisions, right? So that's why hindsight is 2020. When we're looking back at some things, it may be easy to say, well, they shouldn't have done that, or this was out of pocket, right? But again, sometimes those judgment calls are being made, and in retrospect, they shouldn't have been made. And ideally, we would have situations where it never has to come to that, right? Where that they are able to bring people into custody calmly, right, without needing to use any force. And again, regardless of how you may feel if someone's alleged to commit a crime, the other thing to understand is, at that point, everyone is presumed to be innocent until proven guilty. So even if it looks like someone committed a crime, even if they've caught them red-handed, so to speak, it doesn't mean that they're entitled to inferior treatment because of what they may or may not have done, allegedly, right? So again, it's problematic if that gives police officers a license to kind of be unnecessarily excessive or aggressive in detaining people, regardless of what they may or may not have allegedly committed.
Yeah, so I totally understand it's a case by case situation. However, I'll give an example to make things more clear. So how about using improper language when you talk to the police officers when they are stops you or trying to arrest you? Let's assume that somebody at a certain checkpoint was pulled over by a police officer, and then that person start to use that improper terms or language. Would that be a justification for any violence or excessive for any kind of force?
No, absolutely not, right? I mean, again, you can, if there's people certainly give the police the middle finger or swear at them, but that doesn't mean that the police can be, excessive in apprehending you just because of you're expressing your disgust or anger in the situation, right? I mean, that in of itself, right, is maybe not the best choice of words or actions to do, but I mean, it's nothing that would warrant any kind of response from the police, right? So I mean, whether you do that or not, on you, but if you do, it shouldn't get a response, an aggressive response, because you're not resisting arrest, right? You're not escalating the situation. You're not assaulting the police or anything like that. So I mean, of course, I would say a good rule of thumb, as I said earlier, is to try to be as polite and calm in the situation. But even if you are swearing or using improper language, as you put it, that doesn't give them a license to subdue you by any force means necessary, because of you're just being difficult verbally with them.
So within this point, is there any consequences legally for using such language or terms with the police officers? Could they, for example, take any legal action against that person?
I mean, legal action, I mean, perhaps if the language you're using, not just to the police, but let's say you're threatening somebody, right? There's a criminal offense of uttering threats, right? So depending on what you're saying in that regard, I mean, that might lead to an additional criminal charge, right? If you're your language, rises to that kind of level. So again, that might be something that they may do, right? I mean, but other than that, I mean, of course, obviously, if you're accusing them of something and it's defamatory for whatever reason, right? There's civil litigation for defamation in that regard, right? But I mean, in sort of the scenario you pointed out, I mean, unless, like I said, there's a threat made to the police officer, just using colorful language, let's call it, is not a crime or not something that's going to attract legal consequences.
I see. I totally understand. So, still within the arresting, so when somebody get arrested, is there any initial investigation need to be conducted? And if the answer is yes, who will do that investigation, and what are the steps will be built on this investigation?
Well, I mean, it really, again, it depends. If, for example, sometimes you'll see on the news, a story that people have, gotten away, and then there's, an investigation done just to try to identify who they are. There may be, a warrant for that person once they're identified for their arrest, and then the police can, if they have that warrant, can go and find that person at their address, called a feeney warrant, right? And then they can go into their house and arrest them there. Other times, a lot crime happens and the police are there at the scene, right? And they don't necessarily go through that process because they see you've committed an offense. So, their investigation will happen afterwards, right? That they'll arrest the person, they'll charge them, and then they'll ask, like I said, questions of maybe witnesses, or they may have surveillance video and so forth. So again, I mean, in either context, if there is an investigation, right, and you're suspected of committing an offense, and that's where I think one, it's very important. As you said on the outset, this is public education, legal education, is you consult with a lawyer, criminal defense lawyer, right, who can advise you kind of all of your rights in specific and more detail. But then the second thing, as I've alluded to right from the outset, if there's one big takeaway here, is exercising your right to remain silent, right? Because again, you may think you're being helpful, and if you talk to the police, then then nothing's going to happen. They may even say, look, we're just trying to ask some questions, don't worry. They may be friendly, good cop, as they say, and then somebody might be more scary, right, or bad cop, right, in terms of trying to get you to talk to them. But again, if your story is slightly different later on, or you may be admitting to things you don't realize are criminal offenses, right? As I said, for example, if you said something like, I'm going to kill you, I'm so angry, I'll punch you in the face, and then you repeat that to the police, well, now you've told them essentially you've committed, perhaps an assault or uttering threats, and people don't realize things like that are criminal offenses. And again, especially without having the benefit of talking to a lawyer. So, I mean, by default, almost your first thought should be, again, lawyer told me not to talk to you, or I have the right to remain silent, and then consult with a lawyer, whether it's duty counsel in a situation over the phone, or a lawyer you may know of before even going in for questioning, and then they can give you more detailed, specific advice in that situation.
So the golden rule at such circumstances is keep silent, don't get too excited, don't provide too much details. Okay, so talking about that phone call between you and your lawyer, could anything during this phone call taken against you or using against you? Could that phone call being heard or monitored or observed by the police?
Yeah, absolutely not. You have your right to speak to counsel in private. So again, completely, the police can't be like recording it, or they can't be snooping in on that call. And you hear in the movies, you get this one phone call, right? I mean, often that's, like I said, that's the call that they have to place, right, is to speak to a lawyer and give you privacy. I mean, it makes no sense if the police are listening to you talk to a lawyer, you're not able to speak freely and give instructions and talk to the lawyer. So how can you get proper advice if you're afraid to talk because the police are listening, right? So again, even if it's at the scene, right, they have to kind of give you privacy there. Like sometimes people are in the hospital, and again, I always ask, is there privacy here? Because if the police officer's sitting, or the doctor or somebody's right there next to you, you may not feel comfortable speaking freely. But yeah, so they got to give you that phone call in those situations, so you can get proper legal advice as to, again, reminding you of that, as you call it, the golden rule there of remaining silent. Because again, as much as you may have come to something like this, or you may not remember this, months, years, whenever that situation comes up. And then there's a number of other things there, right? I think you had asked about phones, right? You don't want to unlock your cell phone, give out your password to your phone, because again, you don't have to provide that to the police when you're arrested, right? You may not want to consent to any other types of searches, right? So things like that you may not know of, or you may have forgotten. So important there. As soon as you are arrested, you want to, again, assert your right to remain silent and assert your right to speak to counsel, again, in private, as soon as possible in that situation.
Okay, so what is the limits of the estimated authority that the police officer got in regarding to sending someone free or keep them in detention after they've been arrested?
Right. So, I mean, in the situation, again, if someone's not been charged formally, then there's no reason thereafter, after they've done their, within, it's called habeas corpus, right? Within 24 hours that they're free to go. If someone is charged, then they gotta either release them, or again put them in court within as soon as possible. They're within 24 hours to have a show cause or a bail hearing to determine it by a judge to determine if they should be released. So again, there are limits. You can't just be kind of locked up and kept there for a long period of time. And sometimes I have students and they're coming from different countries, and they don't have those same kinds of provisions, right? So someone could be arrested and detained in prison for weeks or something without knowing why they're there and what they're being charged with. And so here we have these constitutional rights there in our Charter of Rights and Freedom that they can't just hold them without reason for an indefinite time period. And again, if they are being charged, then they have the right to have a show cause or a bail hearing within that 24-hour period of time there.
So before I ask my next question, I'm encouraging also our audience, if you have any question, please feel free to type it into the comments, whether you are watching us through Facebook, YouTube, LinkedIn, or Twitter. So John Paul, what if something happened from the police and somebody would like to file a complaint against that behavior? What if somebody was mistreated? What if somebody was treated in some kind of an excessive violence? And sometimes things could not be so obvious. For example, those handcuffs could be tightened to a point where they are really painful. Nobody need to give, for example, slaps to in front of everyone, but things could be done in a different way. So in such cases, what are the options if somebody got mistreated by the police?
So, I mean, there's a couple of main options. Of course, if that person was charged and as part of that, process, everything happened, then you can, or your lawyer, or even your paralegal who is representing you can raise those charter arguments later on, ahead of trial or at trial, basically saying because of the police misconduct or alleged police misconduct, these charges should be stayed or evidence should be excluded because they obtained it in an improper way. So that's one option. Obviously, if there are charges or there's a proceeding that's going to a trial further. I mean, the other option then is you may want to hire a civil lawyer and launch a lawsuit against the police, right? To if there were damages. I think there was a recent talk you had RRAI about sort of the civil litigation process. So again, if you want to kind of consult about that, but again, the police are no different than anyone else who may have committed a tort, right? If there's injuries suffered, you would have to assert again and prove that there was damages and it was caused by them on a balance of probabilities. So basically saying it's more likely that it's happened than it didn't happen. And if you're successful, if it does go to a trial, or if you raise this civilly, that you may be entitled to some kind of compensation, right? So either on the criminal vein, it may lead to the charges being withdrawn or stayed against you because of their alleged misconduct, or on the civil side, it may lead to an amount of compensation provided for, again, breaching your rights, like a false imprisonment or malicious prosecution or something along those lines that you can perhaps obtain compensation for.
Okay, so what are the value of the police investigation within the whole judicial process? We know that the prosecutor or the Crown need to prove the guilty beyond reasonable doubt. So how much the prosecutor, the Crown, would count on police investigation? Did they initiate their own investigation, or did they consult that police investigation as consultation document, if I may call it? Because it's different between the two legal systems, that civil law jurisdictions and the common law. So what's the situation here?
So again, in let's say in Ontario, to be specific, in London, right? That first of all, there's a process of, as we were talking about, the police are investigating. They lay a charge, and then they give you paperwork. Either they release you, telling you to abide by these conditions and show up to court, and that's it for the police in terms of their role. In the matter. I mean, they'll continue. Obviously, they'll have their notes that they've taken, and they'll pass along, any material like those notes to the Crown, who then takes over carriage. The Crown Attorney's Office there, who takes over carriage of the matter. So once it's in the Crown's hands, they can decide whether they want to proceed on the charges. They may look for a resolution with the accused or counsel, or via the counsel for the accused, or they may want to proceed through trial, right? So, I mean, the police officer that at trial would be a potential witness. And again, this is the same for even the Highway Traffic Act offenses, right? If let's say there's an allegation you failed to stop at a red light, or you were speeding now, they would have to call the officer, and they would be a witness to explain essentially, this is what I observed, and this is this person breaking the law. So in the criminal context, then the officer or officers would be called as witnesses, and they'd give evidence. They'd be asked questions by the Crown. They'd be cross-examined by the defense counsel. And accordingly, as you correctly pointed out, if the Crown has proven their case beyond a reasonable doubt, they've established and identified, again, beyond a reasonable doubt, that the accused was the one who committed this crime. They've explained that they've committed the act, and they have the requisite mental element, so that it's called the mens rea, the mental element of the crime, as well as the act. If they can establish that with that police evidence and maybe third-party witnesses beyond a reasonable doubt, then it would result in a conviction for the accused, right? Again, just because you're charged with a criminal offense doesn't mean you are guilty of a criminal offense. A lot of times I get that people are worried, like, do I have a criminal record now? And again, it's only if you are later convicted where the evidence is established beyond a reasonable doubt. And the burden the responsibility is on the Crown to prove the case beyond a reasonable doubt, not you have to prove you're innocent, which again, sometimes people from different backgrounds will say that's not how it is in my country, right? That we have to show that we're innocent. Here, of course, again, you're innocent until proven guilty. So if they can't, and again, it doesn't mean, you know, maybe they have a really strong case, but there's some doubt to the guilt, then you have to be acquitted.
Thank you, John Paul. Last but not least, you've mentioned that term mens rea. So could you please elaborate a little bit about this before we wrap up this session?
Yes, I mean, it's important also there has to be, you know, the requisite mental element, as I said before. So meaning if you know, committed an act, but you know, it was inadvertent in some cases, then you know, you wouldn't necessarily have that. And again, without going too deep into it, the context of certain things, right? Like even if you didn't even if you didn't mean to cause the injury, but it happened because you were being negligent or reckless in some cases, that makes out the offense. But they have to establish that as well, right? So a good example, I was talking with students recently in class, was these self-checkouts at Walmart and, you know, other stores, right? If you, for example, you know, didn't realize that you didn't scan something, and they come in and stop you and say, well, you didn't pay for this and we're going to charge you with theft, and it goes to court and everything. I mean, again, if it was inadvertent, if it was a mistake of fact, you thought it was, you could raise that as a defense. I thought it was scanned. I didn't realize it wasn't. Again, it was accidental, right? Then you know, that might be a situation where they don't have the mens rea there.
Yeah, sometimes people get confused, especially when there is things just like each other. I do remember once I was trying to open a car, same make, same color, and I was when I put that key, the alarm started, and it was just like the same. So in such case, I can just use the mens rea as defense. I was not intended to do so.
Yeah, I mean, obviously, if it goes all that way, right? I mean, hopefully, in a situation like that, you know, they don't even charge you, right? But again, you never know, right? I mean, given that there's a lot of car thefts and things like that recently, right? That how would they be able to distinguish? And that's why I think going back to the original point, you know, you may feel like I better explain all of this and go into the story, but again. Because if you may not remember it correctly, you know, a year later, if it goes to trial, then whatever you've told the police there may be inconsistent with what you remember later on, and that sort of speaks to your credibility at a trial, right? So that's why it's very important to remain silent, even if you think by talking and explain, you know, I just thought it was the wrong car, you know, you're going to put yourself in a worse situation by talking and trying to explain your way out of that situation, right? So again, even where it may not make sense, no, you're better off to just assert your right to remain silent, ask to speak to a lawyer, and again, because if they can't establish all of those elements later on, then you'd be found not guilty.
Thank you very much, John Paul. So anything you would like to say before we wrap up this session? And again, if there is any questions, I also encourage our audience, if there is any other questions, please feel free to ask.
Yeah, so if anything else comes in, by all means, ask it right after this. But I think, again, the most important thing is understanding, and it's very difficult, again, because if you're ever in that situation, as I said, it's very anxious and stressful. And again, even if you know, you may have done nothing wrong, right? I mean, just by being in that situation, it induces, you know, that sort of what's going on here, especially if you're new to the country and you don't know in terms of, you know, what to do, right? And I think the first and most important thing takeaway there is, again, you know, try to be as calm as you can, but remain silent if they're asking you a bunch of questions. Generally speaking, right, there are some situations like, if you're pulled over, you got to provide your driver's license and things like that in a car. But otherwise, where possible, assert your right to remain silent. Ask to speak to a lawyer if you're being arrested. And again, you'll get more specific, detailed advice from telephone duty counsel if it's them, or a specific lawyer you may know and feel comfortable talking with. And again, before they go any further with questions for you after that point, they got to try to facilitate and implement. And I mean, one, they got to inform you of that right. Two, they got to implement, like actually call those people that you've asked to speak to, those lawyers you've asked to speak to, before they go any further. So again, remember those two things, right? To remain silent and ask for legal counsel. And again, depending on the situation, that can be minutes afterwards in some cases, right? Sometimes if we don't have any calls, the police call, it goes directly through to telephone duty counsel. So I mean, minutes later, you can already be on the phone speaking to counsel. So don't forget, again, and the police will have to tell you again of your right to counsel when they are arresting you. But again, remain silent, ask to speak to counsel, and again, that'll hopefully alleviate the situation. And even if it's just calming you down and having this explained to you again, and try to navigate that situation.
Thank you so much. Well, at the end of this session, John Paul, thank you very much for this fruitful, very informative conversation. And let's hope that people will stay safe, out of trouble. But if there is lawyers, there is criminal defense lawyers, duty counsels, and they need to remember to remain silent.
Perfect. Thank you so much again for having me. And again, if anyone has any questions, wants to connect with me either on LinkedIn, or you can also check out, I do a lot of other information sessions on justiceandpieces.ca. You can listen to more experienced criminal lawyers that talk about all different parts of the system there, as well as other areas of law if you're interested as well. But thanks again for having me, and thanks for everyone for listening.
Thank you so much. Have a wonderful rest of your day.